Good evening. Roughly 3 years ago, the Bush administration received a first-hand account from one of its own Justice Department officials who volunteered to let himself be waterboarded that it was indeed torture. And they promptly fired him. Our fifth story on the countdown. Despite the ABC News report tonight about former Acting Assistant Attorney General Daniel Levin's ultimate litmus test and the Bush administration's suppression of it, it appears the nominee for Attorney General who will not concur with nor dispute Mr. Levin's conclusion that waterboarding is torture will himself be recommended for approval by the Senate Judiciary Committee. The Levin story first. As acting AG in the Office of Legal Counsel, he was the Justice Department's man in charge of determining which of the so-called enhanced interrogation techniques could be used legally. ABC quoted unidentified sources saying in 2004, Levin volunteered to find out for himself. He went to a military base outside of Washington and was waterboarded. As characterized in the report, Levin said, though he knew he would not die, the experience was so terrifying that waterboarding was clearly torture. That only under the strictest of supervision and in a, quote, highly limited way could waterboarding even possibly be legally used. Yet the administration, he noted, had failed to issue any guidelines about it, about maximum time of use or the presence of medical personnel during use. Levin, ABC reports, was formulating a memo outlining that waterboarding was legally torture when Alberto Gonzales became the Attorney General of the United States. Sensing Levin was, quote, too independent and, quote, not someone who could be counted on, Levin was forced out of his Justice Department post. Levin would say for the record only that it would be inappropriate for him to make any comment on ABC's report, but what he learned and what he tried to say and what happened to him when he tried to say it dovetails with infuriating irony into news that two Democrats on the Senate Judiciary Committee today announced they will break ranks with their own chairman and join Republicans in making Michael Mukasey, a man who says he's not sure whether waterboarding is torture, the top lawman in this country. That all happened within the span of just a couple of hours this afternoon. First, Judiciary Chair Pat Leahy became the fifth Democrat on the committee, joining Senators Biden, Kennedy, Durbin, and Whitehouse to oppose Mukasey's nomination, which is set for committee vote next Tuesday.
Judge Mukasey was not asked to evaluate any secret facts and circumstances. He was asked a very clear question: is waterboarding illegal? American law makes torture illegal, and waterboarding is torture, and under American law, it is illegal. It is frankly not dependent on any, to use his quote, relevant facts and circumstances of the techniques past or proposed use. That might be a lawyer-like argument, but it's not accurate, and it doesn't reflect what is America.
Not an hour and a half later, California's Dianne Feinstein became the first committee Democrat to announce support for Mukasey. Approximately 1 minute later, Chuck Schumer of New York followed suit. Schumer closely watched in this drama after suggesting Mukasey, a fellow New Yorker, to President Bush, only to have Mukasey, in both his verbal and written replies, raise serious questions among Democrats and even some Republicans about his positions on the power of the presidency and even Civil Rights 101 softballs, such as whether waterboarding constitutes torture. Let's turn now to MSNBC political analyst, Newsweek's senior White House correspondent, Richard Wolfe. Richard, good evening.
Good evening, Keith.
Let's begin with the ABC report big picture first. What's the fallout likely to be for the Bush administration with the revelation that the acting assistant attorney general who was in charge of assessing what was torture and what was not let himself be waterboarded, determined, yeah, legally that's torture, and they fired him?
Well, the impact for the Bush administration, first of all, remember that when I asked the president recently what his definition of torture was, he said it's whatever the lawyers said it was. And it turns out his lawyers said it was, well, waterboarding. So they have a credibility problem, another one, and the semantic games they've played about torture have run out of steam. I think it also has an impact, frankly, on the presidential race. You have Rudy Giuliani going out there saying that waterboarding is fine. The only problem is the way the liberal media, he says, describes it. And clearly, it's not just the, quote, liberal media here. If Justice Department officials undergo this and say it's torture, then come on, guys, it's torture.
Now, this isn't a member of the liberal. Mr. Levin was the acting assistant attorney general in charge of determining what was legal and what was torture and what was in between. Now, what is the practical response from the White House going to be to this? Is it to go out a la Giuliani, as you just suggested? Is their story on Monday going to be, or Sunday even, ABC, not patriots, terrorists, perhaps, for revealing that the White House shot its own messenger in this one?
Well, amazingly enough, the White House isn't as crude as Rudy Giuliani. I think there are three things they do in this case, and three things they say. One, this is somehow out of date. It's been superseded by all sorts of legal commitments and reviews that the administration has said. But two, they can't talk about it because it's all super secret and confidential. And three, that America doesn't torture. And, you know, they close down the conversation that way. I imagine they are doing that right now.
But they need the enabling of the Democrats regarding Mukasey. Does this conceivably do anything to the nomination process, which, as of 4 hours ago, seemed signed, sealed, and delivered? Specifically, could Feinstein, could Schumer do 180s on this, saying, no, we have to have that answer now?
Well, from what I know of Feinstein and Schumer, I don't think that's likely. It ought to give them pause for thought. Look, in a sense, I can understand Schumer. There's a whole New York patronage system that this is part of. Feinstein makes you sort of scratch your head here. And remember, this really hasn't boiled down to the issue of the definition of torture or waterboarding. It's come down to the question of legal jeopardy for CIA interrogators who used this method. Everybody could deal with this in a separate way, in a separate avenue, and deal with Mukasey separately, but they have chosen to take this path, and it's a very narrow political avenue they've taken.
And the cover story for it, at least for Senator Schumer, having an acting attorney general, which we do now in the person of Peter Keisler, would be worse for the country, giving the White House freedoms that Mr. Mukasey presumably would deny it. Is that political cover, or is there some reasoning there?
Well, I think people are impressed with the integrity generally of Judge Mukasey, and certainly his record on the bench suggests that he's been put in a very difficult situation. Again, why would the administration give him no wiggle room at all to deal with the legal jeopardy situation that he's been dancing around? You know, the question here is whether Democrats just want to move on, and I think they do.
Richard Wolfe, our political analyst, senior White House correspondent for Newsweek. As always, great thanks. Have a good weekend.
Thanks, Keith.
Putting political questions